Welcome to Education Forum. I'm Herman Badillo, Chairman of the Board of Trustees of the City University. The improvement of education affects all New Yorkers. This program will focus on the key educational issues and challenges before us all. My guest today is Michael A. Rebell, who is the Executive Director and Counsel of the Campaign for Fiscal Equity. That's a group, a nonprofit organization of parents, school boards, and other people who've been, for many years, trying to change the school aid formula for the City of New York in order to ensure that the Board of Education and the students of New York City get far more assistance. And a couple of months ago, they got a fantastic opinion for Judge Lennon LeGrasse, a Supreme Court Justice, 200-page opinion, which mandated that the state legislature take action by September 15th of this year to revise the school aid formula because he found that the state constitution has been violated. He found that the state constitution required what he called a sound basic education, and that standard was not met. And I think that I haven't read any opinion that is as outstanding as that one. Took a long time to get that, didn't it?
It really did, Herman. We began this case in 1993. We actually had a preliminary ruling from the Court of Appeals, the highest court in the state, in 1995. They were the ones who initially declared that every student has the right to a sound basic education under the state constitution. And they sent the case back to Justice DeGrasse to determine whether students in New York City were getting that opportunity. We had a 7-month trial, an enormous trial, and on trial was every aspect of the New York City school system, every aspect of the state finance system. So the 200 pages, believe it or not, was a concise summary of the voluminous evidence, and it is a powerful statement.
Well, the part that I found most impressive was the section where Judge LeGrasse talks about how few of the students in the New York City public school system get a real high school education. He pointed out that 30% of the students never get a high school education, 10% get a GED, which he said was worthless, then 48% get a high school diploma, but it's only gives them the capacity to read and write at 6th to 9th grade levels. So that adds up to 88%, so it leaves only 12% who get a real high school diploma. I don't think anyone had spelled it out that dramatically.
That's exactly right. And this decision, of course, dovetails with the reforms that the State Board of Regents is trying to put in to upgrade the caliber of education in the city and throughout the state. And effective, actually on a transition basis this year, but even more so in the next 2 or 3 years, every student in New York City and throughout the state who gets a high school diploma in New York is going to have to pass 5 rigorous Regents exams. And that's the figure you came up with. In the past, only 12% of New York City students reached that level. Now that all of them, or at least we've only had, as you said, about 50–60% have graduated high school. We want to increase that number, but we want that high school diploma to mean a lot more than it has in the past.
Well, if only 12% are getting a Regents diploma now, how is it going to be possible in the next couple of years that you have 88%, the 88% who are not getting a Regents diploma? Or is it more likely that what we saw in the last week or two, that is an increase in the high school dropout rate, will come about because when students realize that they can't pass the Regents exam, they drop out?
Well, I think the evidence has shown that when you give people not only the challenge and the standards, but also the resources and the opportunity to deal with them, the overwhelming majority are going to rise to that level. Some won't, but I think the overwhelming majority will. And what's really important about Judge DeGrasse's decision, aside from his analysis of the funding deficiencies and the shortcomings in the system, is the deep analysis of what this concept of sound basic education means and what the Constitution requires. And he equated it, following a tentative definition the Court of Appeals put out there, with preparing students to be citizens, to be civically engaged in the 21st century, and to be capable of sustained competitive employment.
Yeah, he set up a very high standard, which up to now has not been a requirement for a high school diploma.
That's right, and the regents have said it's going to be the requirement. What Justice DeGrasse's decision is going to do is make sure that the legislature and the governor provide the resources and the opportunities for all kids to have a fair shot at meeting that standard.
Now, however, as we all know, the governor is appealing that decision. And what is the likelihood that this will be postponed for years and years?
Well, I don't think it's going to be years and years. I can say two things about that, Herman. One is we are in court right now. The governor just recently filed his notice of appeal, and we've moved promptly for what's called an expedited appeal. My estimate is that we should be able to finish this appeals process within a year or two, because I think the courts are aware of this case. As I mentioned, it's been to the Court of Appeals. They knew it would be coming back to them. They, in fact, gave a tentative definition of sound basic education, told Judge DeGrasse to gather evidence and fill it out, and then they would revisit the issue. So when they're that aware of it, they know it's major public policy, it's going to be on the fast track.
So you plan to bypass the appellate division and go right up to the Court of Appeals?
No, it looks like we're going to have to go to the appellate division. It's actually the decision of the Attorney General because they're the appellants. But the way the rules work out, in some cases you can go right to the Court of Appeals. But this one, because we have a statutory claim in addition to the constitutional claim, we have a Title VI race discrimination claim, it probably has to go through the appellate division.
But even if there is an appeal, that does not prevent the legislature this year and this session from taking action to implement that decision, right?
You're exactly right. And you know, the governor is on record. The week before this decision came out, the governor himself said that this current state aid system is a dinosaur that should go on the ash heap of history. Those were his words. And we're taking him at his words, and we're saying, look, Governor, you're appealing, whatever technical legal reasons you have for appealing, whatever you want the courts to clarify, that's fine. But don't hold the children hostage. If everybody is in agreement, the State Board of Regents, the governor, the judge, everybody has said this system has to go. Let's make this the last year. Let's not delay another year or two and kids not getting their opportunities.
Okay, but before we go into the details of the judge's opinion, assuming that there is a desire to carry it out, how much money would it cost to give additional aid to New York City? And where would the money come from?
Well, Judge DeGrasse was very careful not to be in the position of micromanaging. He didn't write a new state formula. He didn't specify the amount of money New York City needs. What he did do is put down 6 basic guidelines or constitutional parameters. And the first of them is that the legislature needs to cost out to determine precisely how much money is needed to provide each aspect of a sound basic education. Now, this is a methodology that's been done in about 12 other states. There have been court orders like this in a couple of dozen states, but this approach
Give me
of
an
costing
example
out,
of a state where that has been done.
in Wyoming recently, they hired a group of consultants, objective, independent people who did a process of bringing teachers, parents, administrators together, experts in the area, and they went over each issue. Class sizes, what size should it be, how much is that going to cost, what's a competitive teacher's salary in this labor market, what do you need fairly for chemistry labs, for fixing facilities. It's complicated, but it's doable, and
But
it's
the
been
problem
done.
in New York State is a little bit different from other states because we're not talking about the school formula for the entire state. We're only talking about New York City. And as you know, historically, there's always been a fight between the city of New York and upstate, or what they call upstate, which includes Long Island. And it's for that reason, because New York City doesn't have a majority of the legislators, that it's been impossible to revise the formula because we don't have the support from the other fellows.
The judge was very savvy on that, Herman. What he did is say, because New York City is such a large proportion of the state when it comes to education, that you can't make major changes for New York City without affecting the whole state. So he invalidated the formula for the entire state. It's not just New York City. They've got to start from scratch. They've got to throw out the entire funding for the state and start with this costing out of what sound basic education will require for all districts throughout the state. The judge specifically said that. And that's been very helpful to us because, as you very rightly pointed out, historically, especially in education finance, there's been a tremendous upstate-downstate confrontation. We're going to get past that because a lot of rural districts upstate, a lot of poor cities, certainly the other big 4 cities, all are going to benefit from this ruling. In fact, the State Education Department has a list of 205 what they designate high-need districts that are not getting enough resources to provide the opportunities needed for their own regents' learning standards. New York's only one of the 205. So the other 204 districts are going to benefit from this. And by the way, the judge has said nothing about a Robin Hood game. He's not saying you have to take from the rich districts. If they need what they have now to provide this opportunity, that's constitutionally mandated also.
But from a practical point of view, how would additional aid be provided to New York City and those rural upstate districts without increasing taxes or taking it away from some of the wealthier districts?
Well, what the judge is saying, and we strongly support, is the first step here is to determine the need to cost out what's required. Once we know what's required, and I think it is going to mean some additional resources, then it's up to the legislature and the governor to supply that need. Fortunately, this year we've got a surplus of over $2 billion, so we can get a start without having to face that difficult tax question. I think this is going to require radical change, but probably it's something that should be phased in. The judge was very careful also to say that the state should come up with a new accountability system to make sure that any increased revenues are not just thrown at the problem. So I think with careful phasing in, taking account of the surplus, the governor's done a very good job of increasing spending in many areas, including education, without raising taxes so far. I'm not sure whether we have to come to that tax issue. We may have to, but the first job is to determine what's needed.
Well, let's take some of the illustrations the judge used. For example, he talked about smaller classes, and he was very specific. He said, for example, in the 7th grade, the classes should be no more than 26 students. My wife happens to be a 7th grade teacher in the New York City public school system. She has 4 classes with 36, 37 students. That's a lot of students to cut down. And the judge also recommended very substantial increases in lower grades. So you have a couple of problems there. First of all, the cost of reducing class size, and secondly, finding the space, because you're going to reduce class size, you need more classrooms for the same number of students. So you got 2 problems, the class size and building schools, which is going to take time. How do you meet that problem?
Well, you're exactly right. Now, the legislature is already on record on the class size issue as saying for the lower grades, the class sizes in New York City and throughout the state actually should be 20. I don't think the legislature's spoken to the 7th grade level. We've actually been recommending about 24 for that level, which is the state average. But it's going to have to be phased in. We need to get the building sizes in the meantime. But that's why we think what needs to be done here is careful planning. We need to have an objective analysis of what the goals are, both in terms of the buildings, the class sizes, and all the rest. And the judge's order says appropriate class sizes. He is leaving a little room for judgment. But there's a record there of what's needed for effective class sizes. We had enormous input here, experts from all over the country. We went into detail on the Tennessee STAR study on class size, for instance, which emphatically and I think conclusively shows that smaller class size makes a difference. So there's pressure for smaller class sizes, but exactly what the cost is, we've got to figure out.
Okay, let's take up some more items right after this announcement.
You don't have to like me.
Or you can. You don't have to be my friend.
But you might like me if you got to know me.
You don't have to be my roommate.
I am gonna be your neighbor. You don't have to run with me.
You really don't have to run away from me.
You may not like what I have to say.
But hear me.
Hear me.
Hear me out. Man, we're not all that different. I like good food.
Good music.
I love my mom. Yeah, I want to fall in love.
Madly.
I want a good job.
I want my kids to live in a world
Where they're safe and loved.
And respected for who they are.
You don't have to like me, but if you talk to me,
You might.
we can end prejudice if we talk to each other.
Call.
Tell us what you do.
Together we can build one America.
We're back today with Michael Rebell, who is the Executive Director and the General Counsel for the Campaign for Fiscal Equity, an organization, a nonprofit organization of community groups, which just won a landmark case in the Supreme Court mandating that by September of this year there be a new school aid formula, not just for New York City but for the whole state. And you were telling me during the break that you have support from upstate groups. Tell us about that.
Yeah, well, you know, Herman, you mentioned earlier this historic upstate-downstate split in education, finance, and other political areas in New York State. We were aware of that, and at the time we started the trial, about 5 years ago, we started thinking about this remedy stage, and we anticipated it. One thing we did is start what we called a public engagement process. We reached out to people all over the state. We've had more than 30 forums in every corner of this state. I sometimes say I may be the only person other than Hillary Clinton that spent more than 3 nights in Elmira. But as a result of our efforts, we really have been able to forge alliances with many rural, small city, and even suburban districts throughout the state. We have strong support on Long Island with the Refit Group, and perhaps most significantly is the fact that there's a group called the Mid-States Consortium of School Districts, which represents about 240 districts, mainly small rural districts in the central New York area, but they're more than 1/3 of all the districts in the state. And they have publicly gone on record as applauding the CFE decision, saying it's long overdue, it's what's needed to reform education finance for all districts throughout the state. And by the way, they're the first ones who put out a formula that they're proposing that's consistent with the judge's order. Now, we're not necessarily endorsing that. We've got to study it more, but I think it's a good starting point. And when you asked how much things are going to cost, their approach would cost $3.4 billion.
Throughout the state?
Throughout the state, of which New York City would get about half, and the other districts would get about half. They're proposing phasing it in over 2 or 3 years. So as I say, we think there has to be a more precise costing out study before we can really sit down with the monies. But this group, at least, is talking about $3.4 billion.
When you talk about other groups throughout the state, one of the things that struck me reading the decision is, shouldn't the city have to contribute more? That is, the city of New York. And as you know, there's a mayoral campaign going on in New York City this year. What should the mayoral candidates be saying about the city's responsibility under this decision?
Well, I think, again, I can't emphasize this too much. The first order of business here is this cost analysis and determining what's needed. Once we know what's needed, just for argument's sake, let's say the $3.4 billion this upstate group is talking about, then there's a fair political debate about how much of it should come from the state and how much of any of the increase should come from the city. The one thing the judge clearly did hold is, under the state constitution, education is a state responsibility and the buck stops with the legislature. Now, the legislature can determine that it wants to set up a system that requires New York City to pay more or less. The legislature also can put a maintenance of effort law in there to make sure that at the least the city doesn't cut its spending, which they've done in years past.
Because the legislature, in effect, now sets up that kind of formula by providing a percentage, 30-some percent, to the city, and therefore that identifies the city's responsibilities, isn't that so?
It identifies its responsibility. One of the problems in years past was it may have identified it, but it didn't legally require the city to carry its share of the load. So when you had a lot of pressure in the early 90s when we were having budget cutbacks, the advocacy groups might have gone to Albany and, say, gotten a $300 million increase for the New York City public schools, but then when the money came to the city council and the mayor would siphon half of it off for welfare or police or whatever. I'm not saying those are not valid concerns, but if there's a constitutional right for education and the legislature is allocating a certain amount for that, it should go to the school children. And we need a maintenance of effort law to make sure that at the least the city doesn't cut its spending for education if extra money flows from this decision.
Let's talk now about some of the other items that the judge mentioned, which are perhaps even more complicated than the issue of reducing class size and the issue of having enough classrooms, and that is having sufficient teachers and having teachers that are adequately trained. We all know that at the present time there's a huge number of teachers in New York City who are teaching, and yet they don't meet the requirements. How is it going to be possible to meet that very quickly?
Well, as you mentioned, Herman, the judge pointed out that about 14% of New York City's teachers currently are uncertified, and many of those who are certified really got through by the skin of their teeth. We examined their test scores on state certification, and about half the people who came in as math teachers in the last 10 years barely made it. So there's a lot to be done in terms of bucking up qualifications. I want to say, by the way, the judge also pointed out that we have a number of dedicated, highly competent teachers, I'm sure your wife is one of them, who have been working against great odds, and he called them heroes. But the problem is there aren't enough of these heroes. I think the bottom line is New York City doesn't pay competitive salaries, and we've got very difficult teaching conditions, and one way or another that problem is going to have to be met.
And that's a huge problem, because it means a very substantial increase just to compete with Westchester and Nassau and Suffolk counties, right?
Right. The judge estimated, based on the evidence in the case, that salary scales in the surrounding suburbs are in the range of 25% higher than they are in New York City. So that takes quite some dedication and quite a heroic stance for a really competent teacher to accept that much of a lower salary.
And then the judge also talked about the need to improve the amount of supplies and materials and to improve the curriculum. That, in effect, calls for a revising of the entire structure, doesn't it?
Well, it does, and I think the Regents' learning standards themselves, the state's own educational policy, called for that. You know, one of the ironies we found out is, under the new Regents' requirements, all students now have to pass a lab science, but we've got a good number of high schools in this city that don't have the labs to allow the students to even get that science, that laboratory experience. So, yeah, we need a fundamental analysis of the needs here and a fundamental reordering of priorities to make sure that the opportunities are there for all the kids.
Now, the attack on the judge's opinion, I assume, is going to be that the power to carry out the mandate of the Constitution resides with the state legislature and the governor, that they are the ones who have to make the ultimate decisions, and that the judiciary does not have the right to interpose itself in such a way that it takes away the legislative power. How do you answer that?
Well, the governor and some of the legislative leaders have made such statements, and there's a very clear answer to that. If they had been carrying out their responsibilities properly for the last 2 decades, we wouldn't have been in court. And unfortunately, this situation is not unique to New York. I mentioned there have been lawsuits like this in more than 40 states. You've had 25 state Supreme Courts at least ordering similar remedies to what Justice DeGrasse ordered here. And his opinion was actually quite balanced, quite objective. He was aware of what happened in all these other states. We wrote a 40-page brief for him summarizing what has gone on in all these other states. And he's not micromanaging. He put down 6 basic principles of constitutional requirements, but the details are still left to the legislature and the governor. And it's really a very appropriate balancing in the separation of power sense of judicial interference to uphold students' rights, but leaving all those difficult tax issues, all of the detailed allocation issues to the legislature and the governor where they should be.
Okay, but there still has not been a decision by the United States Supreme Court, which I assume ultimately will have to come to grips with this issue.
Well, actually, the Supreme Court faced this issue in 1973 in a case that came from Texas. And they held at the time that education is not a fundamental interest under the federal Constitution. They recognized tremendous inequities in funding in Texas, which are similar to the problems we have here. I mean, basically, the issue is the students with the greatest needs get the fewest resources.
But the issue is not really education. The issue is to what extent can the judiciary interfere with the powers of the legislature, because the legislature is the one that really has the budget powers. And if you say that the judge can mandate that additional aid be provided, it affects not only education, but it affects housing, it would affect welfare, it would affect every aspect of government.
Well, it may be, Herman, but the fact is we're dealing with a constitutional system. And when kids have a right to a sound basic education and not getting it, the courts not only may respond, they have to respond. And I just want to get back to Texas because it's very interesting.
Okay.
The U.S. Supreme Court recognized there were inequities in the Texas system, but it said it wasn't a federal constitutional matter. They indicated it ought to go back to the state courts and the state legislatures. Well, that happened. And in 1989, you had a major decision of the Texas Supreme Court, similar to ours, that held the funding system was unconstitutional, called for a radical change. As a result of that radical change, you've had tremendous education reform in Texas, and our new president, who is very proud of the accomplishments of the reforms in Texas and is basically making them a model for what he's proposing for the nation.
I was going to ask you, do you support the Bush proposals? And
I support many parts of it.
And do you think that those proposals might help resolve this problem?
Well, what I want to emphasize is the underpinning for all the education reforms in Texas was straightening out the education finance system. That's the first step, and that's what Justice DeGrasse is asking us to do now. So this has been done in Texas. It's been done in 20 other states. It should be done in New York. Now, if we want to get into the particulars of President Bush's education plan, he's emphasizing accountability and standards, which our regents are already on record as emphasizing. And I think that's already the policy of the state of New York. The really tricky question in the president's plan is how much federal aid are we going to get to do this job? And then there are questions of sanctions and vouchers if schools don't work. I'm not personally in favor of vouchers. Sense I get is that Congress is not going to adopt that part of it, and the president's going to let that slide. So we may actually benefit from this. The timing may be right. We may be getting a substantial increase in federal aid, and maybe that's one of your answers about where this extra money is going to come from to do the right thing for New York City school children.
I hope so. Unfortunately, we're out of time, so good luck on the appeals.
Thank you very much.
You can reach us by email at our website, www.cuny.tv, or write to us at CUNY TV, 365 Fifth Avenue, New York, New York, 10016.